recorded modification process under Article 150, Sub-Article 2, some petitioners argue that the phrase "with necessary modification" in Article 150, Sub-Article 2 of the Constitution is a mandatory constitutional directive requiring Parliament to enact a substantive legislative framework tailored to the distinct office of the Deputy President. They emphasize that unlike the President, the Deputy President enjoys no civil or criminal immunity under Article 143, and therefore impeachment must be treated as a mechanism of last resort. In their view, a mere transposition of the presidential framework through standing orders is inadequate and constitutionally insufficient. The respondents countered that with necessary modification is nothing more than a drafting device requiring only the mechanical substitution of president with deputy president. They maintained that the obligation was discharged through the National Assembly Standing Order 65-2 and Standing Order 79, and that the Parliament's procedural autonomy under Article 124(1) shields its internal arrangements from judicial scrutiny. We are unable to accept the respondents' construction. Taken to its logical conclusion, it renders the phrase superfluous. If the Constitution intended mere substitution, it would not have qualified the incorporation of Article 145 at all. The deliberate insertion of those words signals that the drafters anticipated substantive adaptation as opposed to a mechanical production or drafting convenience. This conclusion is reinforced by the structural asymmetry between the two offices, partly under Article 143. We do agree with the submission that a framework that ignores this distinction has not applied Article 145 with necessary modification. It has applied it without modification at all. The standing orders relied upon by the respondents do not cure this deficiency. National Assembly Standing Order 65-2 and Senate Standing Order 79 merely echo the constitutional command without discharging it. They reproduce the obligation verbatim, but provide no substantive modification at all. The county experience is instructive in this fundamental procedural questions that a comprehensive statutory framework ought to have addressed in advance. The subsequent county government's state officers' removal from office procedure bill of 2024 was Parliament's legislative acknowledgement of that inadequacy. That bill codifies due process protection, imposes timelines, mandates public participation, establishes a hierarchy between statute and standing orders, and resolves ambiguities such as the role of Senate in voting on charges regardless of committee findings. By contrast, the national framework for removal of the deputy president contains none of such safeguards. The very issues agitated in the petitions before us, including the inadequacy of public participation, the role of the special committee, procedural rights of the deputy president, timelines, and neutrality of presiding officers, are precisely the questions a dedicated legislative framework would have foreclosed. Equally, the question on judicial intervention before an impeached president or deputy president is replaced would also be addressed in the legislation. Their resolution through litigation rather than legislation, and the challenges that the impeachment proceedings have brought forth is itself evidence of that lacuna. Courts do not legislate. But it is within the proper constitutional role of the courts to identify legislative gaps and invite Parliament to address them, particularly where those gaps carry the potential for constitutional crisis. We therefore find that the existing framework under Article 150 is structurally inadequate. The absence of a comprehensive structural framework does not preserve parliamentary autonomy. It transfers the resolution of fundamental procedural questions to the courts at considerable cost to institutional certainty and public confidence. We therefore hold that Parliament ought urgently to enact a dedicated statutory framework for the removal of the Deputy President under Article 150. We do observe, however, that the absence of such legislation does not invalidate the impeachment process already undertaken. This is because the Constitution itself, at Articles 144 and 145, sets out the minimum threshold for conducting such proceedings. It is upon this constitutional framework that Parliament relied, ensuring that the process was carried out in a manner designed to safeguard the Deputy President's protections. On timelines, we note that Standing Order 78-2 imposes a 10-day timeline in respect of a special committee investigation. Neither the standing orders nor the Constitution prescribes a timeline for plenary proceedings. The Senate's adoption of a 10-day deadline for its plenary hearing was therefore a self-imposed procedural choice and not a requirement of the standing orders or the Constitution. The Senate was not obligated by any applicable rule to impose that timeline when it elected to proceed by way of plenary, and the petitioners have not demonstrated that the choice to do so was in itself a constitutional violation.
I will now deal with two issues, that is the composition of the National Assembly and IBC, and the issue of the constitutional processes. I'll start with the issue of composition of the National Assembly and the IEBC. Three other issues were raised under the heading, including whether the National Assembly was properly constituted to consider the impeachment motion, whether the nomination of His Excellency Kindiki could take place in the absence of fully constituted IEBC, and whether his nomination as Deputy President was infirm. We shall address these issues in turn. The third petitioner, Honorable Jane Njeri Maina, invited this court to declare that the National Assembly, as presently constituted, was not legally constituted for failure to comply with the constitutionally two-thirds gender principle under Articles 27, 81B, 100, and 261 of the Constitution. She submitted that, as a consequence, the National Assembly is incapable of entertaining or deliberating on the impeachment motion against the Deputy President. She therefore sought declarations impugning both the legality of the National Assembly and the validity of the proceedings arising from its resolution. The respondents opposed that contention. The National Assembly and its clerk maintained that the constitutional requirements concerning the composition of Parliament under Articles 97 and 98 of the Constitution had been satisfied. They admitted that they submitted that the two-thirds gender principle did not render Parliament unlawfully constituted or incapable of functioning, and that Article 261 itself establishes the constitutional mechanism for securing compliance where legislation or implementation has lagged. They warned that acceptance of the petitioner's proposition would invalidate all parliamentary business undertaken since 2013, an outcome they described as constitutionally untenable and absurd. The Speaker of the Senate and the Senate associated themselves with that position and further urged judicial restraint, submitting that despite that the dispute concerning implementation of the two-thirds gender principle remains actively before a duly constituted five-judge bench in Coachella and others. There can be no controversy that the two-thirds gender principle is a constitutional imperative. Article 81B decrees that not more than two-thirds of the members of elective bodies shall be of the same gender. Article 27 and Article 100 reinforce the constitutional commitment to equality, inclusiveness, and equitable representation. The courts of this country have consistently affirmed that gender principle is not ornamental constitutional rhetoric, but a binding constitutional stance that demands implementation. Equally, however, constitutional adjudication must be undertaken within the framework of the Constitution and the dispute resolution mechanisms it establishes. The question before us is not whether the two-thirds gender principle is obligatory. It undoubtedly is. Rather, the narrower and the more immediate question is whether the alleged non-compliance with that constitutional principle rendered the National Assembly illegally constituted as to deprive it of authority to entertain and determine an impeachment motion under Articles 145 and 150 of the Constitution. Article 261 of the Constitution speaks to the timelines within which legislation ought to be passed by Parliament. It also provides for the consequences of failure to pass legislation. On such a failure, a petition may be filed in the High Court, and the court may grant a declaratory order directing Parliament and the Attorney General to take steps to ensure that the required legislation is enacted within the period specified in the order, and to report the progress to the Chief Justice. In the event Parliament fails to enact the legislation in accordance with the court order, the Chief Justice shall advise the President to dissolve Parliament, and the President shall so dissolve Parliament. The new Parliament shall then enact legislation within the timelines contained in the court order, lest it faces similar consequences. The issue of failure by Parliament to enact the legislation on the gender rule has been litigated in courts for relatively long. Further, in an advisory opinion filed in the Supreme Court, other petitions under Article 261 have been filed in the High Court and declarations made. The Honorable Chief Justice even advised the President to dissolve Parliament. It was that advice that elicited the institution of Coachella and others versus Chief Justice Supra. The matter was recently determined by an expanded bench of this court via the judgment delivered on the 5th of June 2026, that is last Friday, where the advice to dissolve Parliament by the Honorable Chief Justice to the President was declared unconstitutional and subsequently quashed for failure to comply with some fundamental procedural steps. The court, however, clarified that the parties were still at liberty to comply with the requisite procedural steps, and that which the law will then follow its course. Therefore, as long as the redress in Article 261 is yet to be fully realized, it will be premature for this court to declare that the National Assembly was not properly constituted to consider the impeachment motion. To that end, the contention fails. The challenge to the IBC was advanced on two related grounds. First, that IBC was constitutionally incapacitated by the absence of commissioners at the material time, such that any verification of His Excellency Kindiki's qualifications being a substantive commission-led function under Article 250, Sub-Article 1, could not lawfully be performed by the Secretariat alone. And second, that the clearance process was consequently a nullity that fatally infected the nomination. The respondents, however, maintained that the midterm replacement mechanism under Article 149, Sub-Article 1, was a sui generis self-executing constitutional process that did not engage the IBC electoral mandate under Article 88, Sub-Article 4, and that the strict eligibility and clearance protocols under Articles 99 and 137 applied exclusively to general elections and not to midterm nomination vetted directly by the National Assembly. Our reading of Article 149, Sub-Article 1, confirms that it is unambiguous, express, and self-contained. It establishes a strict executive legislative process where the president nominates and the National Assembly votes on the deputy president nominee. It makes no reference to IEBC. That omission is not an oversight. It is a deliberate constitutional choice which this court must give full effect. Were it the intention of the drafters to impose a more stringent requirement, nothing would have been easier than to say so expressly, as they did in Articles 99 and 137 in respect to candidates for elective office at a general election. The absence of any equivalent requirement in Article 149, Sub-Article 1 is therefore a considered constitutional choice to be respected. For ease of reference, Article 149, Sub-Article 1 provides as follows: a record vacancy in the office of Deputy President. Within 14 days after a vacancy in the office of Deputy President arises, the President shall nominate a person to fill the vacancy, and the National Assembly shall vote on the nomination within 60 days after receiving it. From a plain reading of the above, we are convinced that no clearance was required by the Deputy President, and that the vote by the National Assembly was an expression of representative authority by the sovereign's elected representative, precisely the constitutional mechanism that Article 149, Sub-Article 1 contemplates. Under Article 1 of the Constitution, sovereign power belongs to the people of Kenya and may be exercised either directly or through their democratically elected representatives. When the National Assembly voted on His Excellency Kindiki's nomination, it did so as the constitutional repository of delegated sovereign authority acting on behalf of the people in accordance with the specific mechanism the Constitution provides for filling in a midterm vacancy in the office of the Deputy President. We equally accept the respondents' submissions that on the deliberate use of the word vote in Article 149(1 as opposed to the words approve or vet that the Constitution employs in other contexts. That distinction is constitutionally significant. Across the Constitution, we note that the word approve is used where Parliament exercises a confirmatory function in relation to executive appointments, as in the approval under Article 132, Sub-Article 2 of Cabinet Secretaries, the Attorney General, the Secretary to the Cabinet, the Principal Secretary, the High Commissioners, Ambassadors, and diplomatic consular representatives, as well as any other state or public officer whom the Constitution requires or empowers the President to appoint or dismiss. The same applies to the approval of the candidates for constitutional offices such as the Chief Justice under Article 166 of the Constitution. In those contexts, approval connotes a deliberate and structured vetting exercise in which Parliament assesses the suitability of the nominee against a prescribed criterion, and in which the IBC or other constitutional bodies may have a role to play in verifying qualifications. The word vet carries similar connotations of structured scrutiny against defined standards. The word vote, by contrast, denotes a direct and immediate exercise of collective democratic will. It is the language of elections and of sovereign determination. Is used in Article 149, Sub-Article 1, signals that the National Assembly's function in the midterm replacement process is not to sit in the judgment of the nominee's suitability, but to exercise on behalf of the people a direct democratic determination on whether the president nominee should fill the vacancy. That determination is political and representative in character, and it is expressed through the ballot of elected members of parliament, each of whom is accountable to their constituents for the vote they cast. It consequently follows that no input or intervention by the IEBC was constitutionally required in the midterm replacement process under Article 149(1). The absence of any IEBC involvement would not have rendered the nomination or the filling of the vacancy unconstitutional. The informational input by the IEBC Secretariat did provide was, in those circumstances, entirely voluntary in character. It was not a condition precedent to the validity of the process, and its presence or absence was constitutionally irrelevant to the outcome. That being so, the fact that the input was provided by the Secretariat in the absence of commissioners is equally irrelevant. If the input was not required at all, the question of whom within the IBC provided it simply does not arise. For completeness, however, and to the extent that any residual question remains about the lawfulness of the Secretariat's involvement, we are satisfied that the informational verification performed by the Secretariat could not have constituted a clearance in the electoral sense, but rather a routine administrative task, and as such not constitutional or policy driven. The same was legally permissible and procedurally valid and fell squarely within the Secretariat's lawful administrative mandate. We draw from the advisory opinion number 4 of 2024 IBC and the Honorable AG, where the Supreme Court gave guidance on the dichotomy that exists between the role of the commissioners and that of the Secretariat in the following words. And I quote, "The Secretariat, under the leadership of the Commission, Secretary and the CEO, is empowered to undertake routine administrative and operational tasks essential for the day-to-day functioning of the Commission. In the same vein, it is necessary to clarify that the absence of commissioners does not of itself vitiate or invalidate administrative actions taken by the Secretariat within the scope of its lawful mandate, including the execution of contracts, management of personnel, procurement, and other functions necessary for institutional continuity. Such acts remain valid and binding, and provided they fall within these bounds of statutory delegation and do not purport to usurp the constitutional function of the Commission as a corporate body," end of quote. To guard against institutional overreach, the Supreme Court carefully delineated where IBC's administrative mandate ends as follows, and I quote once again, "Having concluded as above, a clear distinction must be drawn between administrative continuity by the Secretariat and the exercise of constitutional authority vested in the Commission as a collegial entity. It is our considered view that the exercise of constitutional function expressly reserved for Commission, such as those enumerated under Article 88, Sub-Article 4 of the Constitution, cannot be lawfully discharged in the absence of a properly constituted commission with the requisite quorum as contemplated under Article 250, Sub-Article 1 and Sub-Article 2 of the Constitution," end of quote. This differentiation of responsibility is further contained in Section 11A of the Independent Electoral and Boundaries Commission Act and exposed by the Supreme Court in the Muruli versus Oparanya and 3 others case. For all these reasons, it is our finding that the Secretariat did not travel beyond its mandate. It simply functioned as an information repository. Having so found, we now move to the last sub-issue concerning the constitutional validity of His Excellency Kindiki's nomination. The petitioners anchored the ground on Article 148, sub-Article 1, read with Article 137, contending that His Excellency Kindiki